David Reimer read the document twice. Then he put it down on the kitchen table. Then he picked it up and read it again. Not because he didn't understand it, because he did. The paper was standard legal weight, cream-colored, professionally typeset, the kind of document that looks completely ordinary until you understand what it is saying. And what it was saying, in the measured language of an Ontario probate filing, was that his father had left him nothing, not a reduced share, not a contested portion, nothing. $1.4 million. Farmland outside Stratford that had been in the Reimer family for 31 years. Pension assets that Thomas Reimer had spent 4 decades accumulating. Every financial instrument, every titled asset, every piece of property his father had ever owned transferred in its entirety to Greta Reimer, née Holst, formerly a care assistant from Kitchener, Ontario, whom Thomas had married 8 years before his death, and whom his children had never, not once, been able to speak to their father about, without Greta present in the room. David was 54 years old at this point. He had driven 3 hours from Toronto to Stratford to attend his father's funeral. He had watched Greta stand at the graveside in a grey wool coat, her hand resting on the coffin in a gesture so composed it looked practiced. He had heard her speak at the reception afterward, quietly, with great dignity, about the privilege of caring for Thomas in his final years. He had watched the neighbors nod. He had watched the pastor touch her arm. And standing in his own kitchen in Toronto, staring at that document, he understood something that he had suspected for years and could now no longer dismiss. This did not happen by accident. Thomas William Reimer was born in 1932 in Stratford, Ontario, the second son of a farming family that had worked the same land since 1901. He studied civil engineering at the University of Waterloo on a scholarship he earned himself, graduated in 1956, and spent the next 38 years working for a municipal infrastructure consultancy based in London, Ontario. He was methodical, technically precise, slightly formal in his manner, the kind of man who kept his receipts and read the fine print and believed with the quiet conviction of someone who had built things with his hands and his mind that the world rewarded careful preparation. He married Patricia Holloway in 1961. They had 3 children together. David, born 1957, an accountant in Toronto. Susan, born 1960, a teacher in Guelph. Mark, born 1963, an electrician in Hamilton. Patricia died in 2000, after 39 years of marriage, from complications following a stroke. Thomas was 68 years old. He moved back to the farmstead, full-time, the property he and Patricia had purchased in 1979 as a retirement holding, and for the first 3 years after her death, by the account of his neighbors and his pastor and his oldest friend, Gerald Koss, he managed. Barely, but he managed. Neighbors who knew Thomas in those years described him as a man who had always been most comfortable when someone else was running the house. A man who knew exactly what needed doing, but preferred, if given the choice, to let someone else decide when to do it. It was Gerald Koss who introduced him to Greta Holst, a community supper at St. Andrew's Presbyterian Church, Stratford, in the spring of 2003. Thomas was 71. Greta was 66. Greta had been born in 1937 in Kitchener to a German immigrant family. Her father a toolmaker, her mother a seamstress. She had married once before, briefly, in her early 30s, a marriage that produced no children and ended in separation within 4 years. She had spent the bulk of her working life as a care assistant, residential homes, private placements, home care packages, earning wages that kept her functional but never comfortable. She rented a flat in a modest terrace in Kitchener's East End. She had a small car, a reliable routine, a good reputation with the families she had worked for. What she did not have, at 66, was security. Not in any permanent sense. Not the kind of security that comes from owning something that cannot be taken away. People who knew Greta in those years described her differently depending on who you asked. Her former employers in the care sector spoke of a woman who was attentive, patient, and genuinely good with elderly people. Not performatively, not for show, but with the practiced competence of someone who had spent decades learning what people needed and how to. Neighbors who saw her with Thomas in the early years of their relationship described her as the kind of woman who always knew exactly what Thomas needed before he asked. That sentence, remember it. It will matter later. Thomas and Greta married in September 2003. Thomas was 71. He told Gerald Koss it was the right thing to do. He told his daughter Susan in a phone call that Susan would later describe in court that Greta made the house feel like a home again. David, Susan, and Mark attended the wedding with expressions their neighbors characterized as polite. One of the women from the church who witnessed the ceremony told investigators years later that she remembered thinking the Reimer children looked like people who had already decided they were at a funeral. The farmstead outside Stratford sat on 43 acres of mixed agricultural land, some leased to a neighboring grain operation, some maintained as pasture. The farmhouse itself was a 2-story clapboard structure, white with green shutters, built in the 1940s and renovated twice. It was the kind of property that looks like it has always been there, because in a certain sense, it had. Thomas spoke of it with the specific attachment of a man who associated it not just with money, but with continuity, with the idea that some things persist, that some things outlast the people who love them. It was worth, at the time of Thomas and Greta's marriage, approximately $600,000. By 2011, with rising land values in rural Ontario, it had appreciated to an assessed value of just over $900,000. Thomas's investment and pension portfolio, accumulated across 38 years of professional employment and careful management, stood at approximately $500,000 at the time of his marriage to Greta. Combined estate in the neighborhood of $1.4 million. David Reimer, who worked as an accountant, was aware of those figures in broad terms. He had helped his father with his tax returns until 2005. After 2005, Thomas told him Greta was handling the household administration. David did not push. He would come to wish with the particular bitterness of a man who understands numbers that he had pushed considerably harder. The first time David noticed something was wrong, genuinely, viscerally wrong, not just the low-grade unease he had carried since the wedding, was Christmas 2007. Thomas was 75. He had been diagnosed 2 years earlier with moderate heart failure and the early signs of cognitive decline. Not dementia, his GP had been careful to say, but the kind of gradual, age-related reduction in processing speed and short-term retention that Thomas himself described when David asked him about it directly as getting a bit foggy sometimes. That Christmas, David noticed his father had trouble following conversations that changed direction. He repeated himself twice in the same hour. Not the same story, which Thomas had always done, but the same sentence, the same few minutes apart, with no awareness of the repetition. His hands shook slightly when he poured coffee. And when David asked him about the farm lease renewal, a topic Thomas had always handled with precision and genuine interest, Thomas glanced at Greta before answering. Just a glance, a fraction of a second, but David saw it. "Dad, the lease with the Hendersons, are you renewing it the same terms?" Thomas had looked at Greta. Greta had said quietly, "We renewed it in October, Tom. Standard terms." And Thomas had nodded and said, "That's right, October. Standard terms." David said nothing. He filed the moment somewhere. The second time was Easter 2008. Mark had driven up from Hamilton and Susan had come from Guelph. The three children together at the farm, which had not happened since their mother's funeral. And Greta had been present for every moment of it. Not intrusively. Greta was never intrusive. She was simply always there, bringing tea, managing the meal, redirecting conversations that she felt were tiring Thomas, standing in the kitchen doorway when David tried to have a private word with his father in the back garden. Mark said it first, on the drive back to Hamilton, in a call to David. "She doesn't leave him alone with us." David had said, "She's protective." Mark had said, "Of him or of something else?" They did not yet know, but they were beginning to suspect. And here is the question I keep coming back to, the one that does not have a clean answer. If you had been David Reimer in that garden, watching your 76-year-old father glance at his wife before he answered a question about his own property, what would you have done? What would you have said? Because David said nothing, and his father was dead within 3 years. I am not saying that is David's fault. I am saying that the space between what we notice and what we act on is where a great deal of the damage in this story was done. And that space belongs to more than one person. What none of them knew, because they had not seen the bank records, because they had not been permitted inside Thomas's financial life since Greta took over the household administration, was that between January 2007 and December 2008, 3 of Thomas's 4 investment accounts had been consolidated. The separate accounts, a RRSP, a locked-in retirement account, and a non-registered investment portfolio, had been transferred through a series of transactions approved under a power of attorney that Thomas had signed in November 2006 into a single joint account held in both Thomas and Greta's names. Thomas had signed that power of attorney 3 weeks after his cognitive decline diagnosis. The solicitor who prepared the document was a general practitioner in Stratford named Ronald Fife. He would later tell investigators that Thomas had appeared to understand the document at the time of signing. He would also confirm, under questioning, that Greta had been present throughout the appointment. The power of attorney that transferred legal control of Thomas Reimer's financial life to the woman his children believed was exploiting him had been witnessed by a solicitor who had no reason to object in a meeting his children did not know was happening, in a town none of them lived in, on an ordinary Tuesday morning in November 2006. By the time David found out the account consolidation had happened, Thomas was dead. 2009 was the year the visits stopped. Not entirely, but nearly. Thomas's 3 children would each visit the farm, separately now, because coordinating joint visits had become complicated, and Greta had begun scheduling Thomas's rest periods and medical appointments in ways that coincided with remarkable consistency with the arrival times his children proposed. Susan would later describe it in her witness statement as a feeling of being managed, not refused, never refused, just arranged around. Thomas's world was contracting. That is the word the prosecution would later use, contracting. His circle of contact narrowing gradually across the course of 2008 and 2009 in ways that each seemed individually explicable. He tired more easily. He needed afternoon rest. The GP had advised against stress. His old friend Gerald Koss, who had known Thomas for 40 years, told investigators that somewhere around late 2008, he had stopped being able to reach Thomas directly by phone. That when he called the farmhouse, Greta answered, and that Thomas was always either resting or not feeling well, and that Gerald could leave a message, and Gerald always did, and Thomas called him back with decreasing frequency. Gerald Koss told investigators, "I thought it was the illness. I understand now it may not have been just the illness." What it felt like from the inside, from Thomas's perspective, as his daughter Susan would later piece together from cards and brief calls and 2 visits in 2009 that Greta had not managed to arrange conflicts with, was probably not confinement. It probably felt like comfort, like someone caring for him, like not having to worry about things. That was the terrifying part when you looked at it clearly. Thomas Reimer was not a stupid man. He had been a careful, precise, technically accomplished engineer for 38 years. But he was 77 years old. He had moderate heart failure, his cognitive processing had slowed, and the woman who managed his medications and his appointments and his correspondence and his food and his household and, increasingly, his visitor access was also the woman who held his power of attorney and co-owned his consolidated investment account. The dependency had been built so gradually that Thomas could not see the architecture of it. He just lived inside it. In August 2009, Thomas's will was updated. His original will, drafted in 1998, had divided his estate equally among his 3 children, with a specific provision for the farmland to be held in trust to allow any child who wished to retain it the option to buy out the others at assessed value. The 2009 will left everything to Greta. The solicitor who prepared this document was not Ronald Fife. It was a different practitioner, a younger solicitor in a different Stratford firm, a woman named Catherine Weil, who had not previously acted for Thomas. Greta had located her through a recommendation that Catherine Weil, under cross-examination, would be unable to specifically recall receiving. Thomas had attended the appointment. He had signed the document. Catherine Weil would testify that she had asked Thomas directly, in Greta's presence, whether he understood the full effect of the will and whether this was his genuine wish. Thomas had said yes. Greta had said nothing. She had simply sat. Catherine Weil would also testify, when pressed, that she had noticed Thomas referred to the specific bequests in the will by the wrong amounts twice during the appointment, amounts that differed from the figures in the document, and that she had assumed this was a memory error and had corrected him. She had not flagged this in any written note. She had not requested a capacity assessment. She had asked the question she was required to ask, received the answer she was required to receive, and prepared the document. This would become one of the most significant moments in the trial. 2010 arrived, and Thomas's health declined faster. He was hospitalized 4 times between January and October of that year. Cardiac events twice, a fall resulting in a fractured wrist, and a third admission in July that the hospital described as related to medication management. His digoxin levels had been recorded as elevated on admission, and his prescribing physician, Dr. Anita Prasad at Stratford General Hospital, had adjusted the dosage and issued written guidance to the household caregiver about administration. That caregiver was Greta. The hospital's written guidance on digoxin management was addressed to the woman whom the prosecution would later argue had been using digoxin to accelerate her husband's death. She signed the acknowledgement form. She took the guidance home, and Thomas came home from the hospital. What happened to Thomas's investment accounts during those hospitalizations? That is the question nobody had thought to ask yet. Nobody except eventually a forensic accountant named Paul Strang. Thomas Reimer died on the 14th of March, 2011. He was 79 years old. The cause of death recorded by his attending physician was cardiac failure, consistent with his documented history of progressive heart disease. There was no inquest. There was no autopsy. He had a DNR in place. He had been under medical care for years. Greta called Dr. Prasad. She called the funeral home. She called the pastor. She did not call David. David found out his father was dead from Susan, who found out from a neighbor who had seen the funeral home vehicle at the farm, and phoned the church, and the church had called Susan's number because it was on a contact list from a community event from 4 years before. Thomas Reimer was buried on the 19th of March, 2011, at St. Andrew's Presbyterian Church, Stratford. The funeral was attended by neighbors, church community members, several of Thomas's former professional colleagues, and his 3 children, who stood together on one side of the graveside and watched Greta stand on the other, composed, dignified, her hand resting on the coffin. In that gesture, David would describe years later as the most controlled thing he had ever seen a human being do. Greta delivered a eulogy in which she described her 8 years with Thomas as the greatest privilege of her life. She said that he had been the most loving companion she had ever known. She said that he had faced his illness with grace, and that she had been honored to walk every step of it with him. The church was silent. People cried, and David Reimer stood at the graveside of his father on a cold March morning in rural Ontario, listening to the woman he believed had stolen his father's life describe what a gift that life had been to her. And he felt something that was not grief and was not anger and was not quite either of those things alone. It was the specific sensation of knowing something that you cannot yet prove. 3 weeks later, the probate filing arrived. David read it twice, put it down, read it again. The paper was cream-colored, professionally typeset, standard legal weight, and it said, in the measured language of an Ontario probate filing, that his father had left him nothing. He picked up the phone and called a solicitor, and then he called a second solicitor, and the second solicitor, a civil litigation specialist in Toronto named James Okafor, told David that what he was describing, the will revision, the power of attorney, the account consolidation, the restricted access in the final years, was consistent with a pattern that Ontario courts had examined before, that a challenge on grounds of undue influence and testamentary incapacity was possible, that he would need financial records, and that getting those financial records, given that they were held in Greta's name on a joint account, was going to require a court order. David authorized the application. He did not yet know what those records contained. He was about to find out. The civil litigation order came through in August 2011. James Okafor's firm engaged a forensic accountant. His name was Paul Strang. He was 43 years old, a former bank investigator who had spent 11 years working financial crime cases before moving into private forensic practice. He had reviewed dozens of disputed estate accounts. He had not seen one that looked like this. Strang received the full transaction history of the joint account, now solely in Greta's name following Thomas's death, along with the historical records of the 4 investment accounts that had been consolidated into it between 2007 and 2008. He cross-referenced those transaction records against Thomas's hospital admission records, which the estate solicitor had obtained through a medical records request. It took him 2 weeks. When he called James Okafor's office, he asked to come in person. He did not want to put what he had found in an email. When Paul Strang laid the transaction timeline beside the hospitalization records, side by side, on the meeting room table in James Okafor's office on a Tuesday afternoon in October 2011, every significant withdrawal from the joint investment account had occurred within 72 hours of Thomas being admitted to hospital. Not some of them, not most of them, every single one. And not one significant withdrawal had occurred while Thomas was home. Let that settle for a moment, because what that pattern meant, the thing Paul Strang understood immediately and James Okafor understood within 30 seconds of looking at it, was not consistent with a husband directing financial decisions from his sickbed. It was not consistent with a couple managing their assets together. It was consistent with a person who knew that the window of unsupervised access was open, who knew that when Thomas was hospitalized, Thomas was not watching, that Thomas could not watch. The withdrawals totaled $237,000 across 14 separate transactions. They occurred across 6 of Thomas's 8 hospitalizations between 2008 and 2011. The amounts ranged from $8,000 to $41,000. They were transferred in every case to a sole account in Greta's name at a different financial institution, an account Thomas's name had never appeared on. This was not estate management. This was extraction. David had stopped filing his father's tax returns in 2005 when Greta took over the household administration. He had not pushed, he had told himself it was reasonable. Standing in James Okafor's office, looking at Paul Strang's timeline, he understood that the 2005 decision not to push was the moment the window had opened, and that someone had been watching for exactly that window. James Okafor made a phone call that afternoon, not to a judge, to the Ontario Provincial Police Financial Crimes Unit, because what Paul Strang had found was not a probate dispute, it was a criminal pattern. In his notes from the initial consultation with OPP investigators, Paul Strang described the moment like this. He said he had reviewed hundreds of disputed estate accounts, and he had learned to distinguish between what he called management decisions that look bad in retrospect and what he called structured extraction. He said the difference was in the timing. Careless financial decisions happen randomly. Opportunistic ones happen in windows. He said this account had windows every single time. The OPP Financial Crimes Unit opened a formal investigation in November 2011. They assigned 2 investigators, Detective Constable Rachel Mbeki, a financial crime specialist with 8 years of experience, and Detective Sergeant Mark Hollowell, who had handled 3 elder financial abuse prosecutions in the previous 5 years. They did not tell Greta they were coming. They did not need to yet. What they needed first were the medical records, all of them, including the tissue samples that Stratford General Hospital had retained from Thomas's final admission in February 2011. Retained, as was standard protocol, for a period of 2 years following death. Those samples still existed. The toxicology review was not the investigators' first instinct. Their first instinct was financial. The account records were already a criminal case. The elder financial abuse charge was building itself from Paul Strang's timeline without needing anything additional. But Detective Sergeant Hollowell had read the hospitalization records carefully. He had noticed something about Thomas's July 2010 admission. The elevated digoxin levels on presentation, the written guidance issued to the household caregiver, the subsequent admissions in which digoxin levels continued to trend inconsistently despite the adjusted dosage. He had flagged it to the Crown Attorney's office. The Crown had authorized a toxicological review of the retained tissue samples as a precautionary measure. The results came back in March 2012, 12 months after Thomas's death. The forensic pathologist who reviewed the samples, Dr. Miriam Osei of the Centre for Forensic Sciences in Toronto, prepared a 14-page report. The essential finding was this: digoxin levels in Thomas's preserved tissue were elevated beyond the therapeutic range for his documented prescription dosage. Not dramatically, not at the level that would indicate an acute overdose in a healthy adult, but elevated in a pattern that Dr. Osei described as inconsistent with age-related metabolic changes in a patient whose liver and kidney function, based on his most recent blood panel, had been within expected parameters for his age and condition. In plain terms, Thomas's digoxin levels were higher than they should have been, given what he was prescribed, and his body's ability to process the drug did not fully account for the difference. Digoxin is a cardiac glycoside used to manage heart failure and irregular heart rhythm. Its therapeutic window is narrow. Too little and it does not work. Too much and it becomes toxic. Digoxin toxicity in elderly patients, particularly those with existing cardiac conditions, can produce symptoms that closely mimic the natural progression of heart failure, fatigue, weakness, arrhythmia, death. It does not always leave a clear signature. Dr. Osei was careful in her report. She did not use the word murder. She said the finding was clinically significant and warranted further investigation. She said she could not exclude the possibility of deliberate over-administration as a contributing factor in Thomas Reimer's death. That was enough. In April 2012, Greta Reimer was arrested at the farmhouse, which she had not yet vacated despite the civil litigation freeze order on the estate, on charges of criminal breach of trust, elder financial exploitation, and manslaughter. The power of attorney signed in November 2006, 3 weeks after Thomas's cognitive decline diagnosis, with Greta present throughout the appointment. That document, which had enabled every subsequent financial transaction, was the mechanism the prosecution now argued had been obtained through undue influence. The timing of its execution, the specific 3-week gap between the diagnosis and the signing, became one of the central planks of the Crown's case. That gap had a name in the prosecution's case theory: opportunity. Thomas had been told he was cognitively declining, he had been frightened, and someone had been ready with a document. Greta was released on bail. She retained a defense team, led by a criminal defense solicitor from London, Ontario, named Richard Ford. She returned to the farmhouse and said nothing publicly. She would not say anything publicly for 18 months, not until the trial. Meanwhile, and this is the part that nobody outside the investigation knew, the civil matter was still running alongside the criminal case. James Okafor's team had expanded their financial analysis, and in the summer of 2012, they found the farmland transaction. In January 2011, 6 weeks before Thomas died, a contract had been signed to sell 31 of the farm's 43 acres to a commercial agricultural operation based in Waterloo. The contract had been executed under the power of attorney. The sale had completed in February 2011. The proceeds, approximately $340,000, had been deposited into the sole account in Greta's name. Thomas had been in hospital when the sale was finalized. The farmland that Thomas's original 1998 will had specifically protected, the land he had written a provision around so that his children could retain it if they chose, had been sold 6 weeks before he died, under a power of attorney, into an account his children did not know existed. While Thomas was in a hospital bed, the farmland was gone. It could not be recovered. The new owners had clear title. David received this information on a Tuesday afternoon in September 2012 in James Okafor's office, and he said nothing for a long time. He told a journalist 3 years later in a piece about elder financial abuse in Ontario that the moment he found out about the farmland sale was the moment something in him finished grieving his father and started grieving something else entirely. He said, "My father built that farm up over 30 years. He wrote a will in 1998 that specifically said, 'This land should go to my children if they want it.' He knew what it meant, and she sold it while he was in hospital, 6 weeks before he died, and we can't get it back. No verdict changes that." The criminal trial was scheduled for the spring of 2013. The courtroom in Stratford, Ontario, is a formal, high-ceilinged room with dark wood paneling and tall windows that let in a pale grey light even on sunny mornings. On the first day of Greta Reimer's criminal trial, in April 2013, that room was full. Thomas's 3 children sat together, for the first time since the funeral. Greta sat at the defense table in a dark blue jacket. She was 75 years old. She appeared calm. The Crown Attorney was a veteran prosecutor named Stephanie Chen, who had spent 15 years in financial crime and elder abuse prosecution. She was measured, precise, and entirely without theatrical flourish, which made her more frightening, not less. Richard Ford for the defense was experienced, methodical, and deeply prepared. He had spent months building a case around two essential arguments. First, that Thomas Reimer had directed every financial decision and had the cognitive capacity to do so, and second, that the digoxin elevation was explicable by age-related metabolic changes and fell within the range of variation that could occur in an elderly cardiac patient without any intervention by a third party. The Crown's opening was 45 minutes. Stephanie Chen walked the jury through the financial timeline, the account consolidation, the hospitalization withdrawal pattern, the farmland sale, and described a pattern of deliberate, systematic financial exploitation that had been executed across nearly 5 years. She described the will revision as the product of a vulnerable man whose access to independent legal advice, independent family contact, and independent medical consultation had been progressively reduced by the person who stood to benefit most from his compliance. She told the jury that the digoxin elevation was not a coincidence and was not a metabolic anomaly. It was the final instrument in a plan that had been running since 2006. Richard Ford's opening was 37 minutes. He told the jury that Greta Reimer was a woman who had given 7 years of her life to caring for a man she loved, a man whose children had visited him 4 times in the 3 years before Greta entered his life, and who had found in Greta not a manipulator, but a devoted companion. He told them that the financial decisions had been made jointly, that the power of attorney had been properly executed by a legally competent adult, that the will revision had been witnessed by a solicitor who confirmed Thomas's understanding and intent, and that the digoxin findings were contested by a highly qualified defense expert who would explain to the jury why the elevation was clinically unremarkable. He told them to watch carefully, that the case was not what it appeared to be, and for much of the first 3 weeks, the jury had reason to take that seriously. Thomas's GP, Dr. Anita Prasad, testified that she had always found Thomas to be a willing and engaged patient, that she had no record of concerns about his capacity at the time of the will revision, and that digoxin metabolism in elderly cardiac patients was genuinely variable. Under cross-examination by Stephanie Chen, she confirmed that she had never assessed Thomas's capacity formally, had never met with him alone after 2008, and that Greta had been present at every appointment she could recall from that period. Ronald Fife, the first solicitor, testified that Thomas had understood the power of attorney when he signed it. Under cross-examination, he confirmed that Greta had been present at the appointment and that he had not requested an independent capacity assessment. He said it was not standard practice to do so. He said Thomas had seemed clear. The defense expert on digoxin, Dr. Howard Bassett, a clinical pharmacologist from McMaster University, testified with evident authority that elevated digoxin in preserved tissue samples from elderly cardiac patients was not uncommon, that post-mortem tissue analysis introduced variables that made precise dosage calculation unreliable, and that the levels found in Thomas's samples fell within a range that could plausibly occur without any intervention. Ford pressed this hard. He asked Dr. Bassett whether it was possible to state with scientific certainty that Thomas Reimer had received more digoxin than he was prescribed. Dr. Bassett said no, it was not possible to state that with certainty. And there it was, the defense's most powerful moment, the thing that made the manslaughter charge genuinely uncertain, because certainty, scientific, documented, courtroom admissible certainty, was exactly what the prosecution needed on the manslaughter count, and exactly what the digoxin evidence, by itself, could not fully deliver. The jury was listening. The jury was not certain. And then Catherine Vale took the stand, the solicitor who had prepared the 2009 will, the woman who had asked Thomas directly, in Greta's presence, whether he understood the full effect of the will, the woman who had noticed Thomas referring to the specific bequests by the wrong amounts twice during the appointment, and had assumed it was a memory error. Under direct examination, she confirmed the will had been properly executed. Under cross-examination by Stephanie Chen, she confirmed that Thomas had misquoted the bequest amounts. She confirmed she had not flagged this in any note. She confirmed she had not requested a capacity assessment. And then Stephanie Chen asked her one more question. Miss Weil, in your professional experience, when an individual preparing to sign a testamentary document cannot accurately state the specific amounts contained in that document, what would that ordinarily cause you to consider? Catherine Vale was quiet for a moment. Then she said, "It would ordinarily cause me to consider whether the individual had read the document himself, or whether the document had been explained to him by someone else, and whether he was signing from memory of that explanation, rather than from personal knowledge of the contents." The courtroom was very still. Stephanie Chen let the silence sit for exactly as long as it needed to. Then, she played the recording. The phone call had been made on the 12th of December, 2010, 3 months before Thomas died. It was a call between Thomas and his daughter Susan, recorded, with Susan's knowledge, under her counsel's advice, after Susan had noticed a change in her father's speech patterns and had begun quietly to document what she could. The recording lasted 11 minutes. Thomas's voice was slow, slightly slurred at moments, consistent with his medication, but clear enough. In the recording, Thomas told Susan that he had not seen Gerald Koss for a long time, that he missed Gerald, that he had tried to call Gerald but wasn't sure the call had gone through, that Greta thought it was better for him to rest in the afternoons. Then Thomas said, and the courtroom heard his voice saying this in the specific quiet way of a man who is trying to say something clearly and is not entirely sure he is succeeding. He said, "Susan, I want to talk to James about the farm. Can you get James to call me?" Without, and then there was a sound, a door, and Thomas said, "I've got to go, love. Greta's back." James Okafor, the civil solicitor. Thomas had been trying to reach him, without Greta knowing. He never did. Neighbors described Greta as the kind of woman who always knew exactly what Thomas needed before he asked. That sentence, which opened this story as a warm character detail, a portrait of devoted attentiveness, is the prosecution's definition of coercive control. A carer who has assumed total informational and medical control over a vulnerable adult does not need to state her influence aloud. She does not need to threaten. She simply needs to be present, every time, until the person who might otherwise speak cannot find the space to do it. Thomas Reimer had been trying to call his solicitor without Greta knowing. He had not managed it, and 3 months later, he was dead. The jury deliberated for 6 days. 6 days is a long time. It tells you something. Specifically, it tells you that the jury was divided on at least one count and had to work hard to reach agreement on the rest. Court observers noted, and the foreperson confirmed in a post-verdict interview, that the manslaughter count was the source of the difficulty, that the financial counts were less contested, that the digoxin evidence for some jurors was not sufficient to meet the criminal standard beyond reasonable doubt without the certainty that Dr. Bassett had said science could not provide. But here is the thing the evidence suggests and does not fully confirm. The hospitalization withdrawal pattern, Thomas in hospital, Greta moving money, is documented. The farmland sale while Thomas was hospitalized, documented. The recorded call, Thomas trying to reach his solicitor without Greta knowing, documented. And the digoxin elevation, present, contested, unexplained to a scientific certainty. I will tell you what the jury decided. I will tell you the verdict, but I want you to sit with that elevation for a moment, because the investigators closed their file on it. The court has spoken, and I have read every document in this case, and I am not certain at all, that we know everything there is to know about those final 18 months. The jury filed back into that courtroom on a Thursday morning. Thomas's 3 children were sitting together. Greta was at the defense table. Rachel Mbeki and Mark Hollowell were in the gallery. Paul Strang was there. Gerald Koss was there. And Richard Ford, who had built the best possible defense from the evidence available to him, sat very still. The courtroom went quiet as the foreperson stood. It went quiet in the specific way that courtrooms go quiet when the thing that 12 people have spent 6 days deciding is about to be released into the world and cannot be taken back. Thomas's children held still. Greta looked at the foreperson. On the count of manslaughter, not guilty. On the count of criminal breach of trust, guilty. On the count of elder financial exploitation, guilty. David Reimer did not move for a long moment. Susan put her hand on his arm. Mark looked at the floor. Greta, at the defense table, absorbed the words without visible expression. Richard Ford put his hand briefly on her arm. She did not respond. Rachel Mbeki, in the gallery, said later that she had felt 2 things simultaneously: relief and frustration in almost equal measure. Relief that the financial counts had held. Frustration that the manslaughter count had not. She said she understood the jury's reasoning. She said she respected the standard of proof. She said she went home that evening and sat in her kitchen for a long time. Paul Strang was in the gallery. He had laid the transaction timeline beside the hospitalization records on a meeting room table in October 2011. He had found the windows. He had found the pattern. The financial case was his. He said nothing to reporters outside. He had nothing to say. Gerald Koss, Thomas's oldest friend, the man who had been shut out of Thomas's life across the final years, the man who could no longer reach him by phone by late 2008, whose messages Greta had passed on with decreasing frequency. Gerald Koss sat in the back row of the public gallery and cried with a specific quiet dignity that everyone around him pretended not to notice. The sentence was delivered 3 weeks later. Greta Reimer was sentenced to 4 years in a federal correctional institution. The judge, in his sentencing remarks, described the exploitation as systematic, deliberate, and extended across a period during which the victim had been progressively isolated from the people and the resources that might otherwise have protected him. He noted the farmland sale, the specific, irreversible nature of it. He noted the recorded phone call. He said that the evidence of financial exploitation was overwhelming, and that the sentence needed to reflect both its duration and its premeditation. 4 years. Greta would serve a portion of that sentence before becoming eligible for parole consideration. She maintained throughout, in her statement to the court before sentencing, in reported conversations with prison counselors, in everything documented after the verdict, that she had not stolen from Thomas. She said she had claimed a future she had earned. She said the money was what she was owed for everything she had given him. The woman who had built her public identity as a devoted carer, who had been praised at the funeral, who had stood at the graveside with composed grief, who had described Thomas as the greatest privilege of her life. That woman, sitting in a courtroom in Stratford, Ontario, described the $237,000 she had extracted from his accounts during his hospitalizations as something she had earned. Thomas could not respond to that. Thomas had been dead for 2 years by the time she said it. The civil settlement between Greta's estate interests and Thomas's children was reached 6 months after the criminal verdict. The terms were sealed. What is known is that the liquid assets remaining in the accounts after legal costs and the civil litigation process were divided between the 3 children. The amounts were substantially less than their inheritance under the original 1998 will would have been. The farmland had been sold in February 2011. The farmhouse, the 2-story clapboard structure with the white walls and the green shutters, the property Thomas had bought with Patricia in 1979, the place he had described to Gerald Koss as the one thing he wanted to leave behind. That property remained part of the estate and was eventually returned to the children through the civil settlement. David Reimer sold it within a year. He said, in the statement he made to reporters outside the court on the day of sentencing, that the verdict was both a vindication and a permanent wound. He said the justice system had done what it could. He said it could not give them back the time, or the land, or the version of their father's death that did not include this. He said, he spent 7 years with someone who we now know treated his vulnerability as an opportunity, and we will spend the rest of our lives knowing that part of that vulnerability, part of it, was one we created. We weren't there. We should have been there. That last sentence, he did not have to say it. He could have framed himself and his siblings purely as victims. He was a victim. The court had said so. But he said it anyway because he was an honest man, and because the truth of this story does not divide cleanly into a side that was entirely wronged and a side that was entirely wrong. Greta Holst grew up in rented accommodation in a working-class family with a father who made tools and a mother who made clothes and no safety net underneath any of it. She spent 40 years caring for other people's parents, people whose children visited twice a year, and called it devotion. She watched Thomas's children absent themselves from his life across the years before she entered it. She arrived at 66 with nothing permanent to her name, and she found a man who chose her, genuinely chose her as far as anyone could ever determine. And she experienced that choice as the correction of an injustice that had defined her entire life. None of that excuses what she did. None of it comes close. But it explains what the prosecutor cannot explain, what the defense cannot fully excuse, and what the evidence cannot resolve, which is the specific and terrible way that genuine feeling and deliberate calculation can become so entangled inside one person that they can no longer see the line between them, that they can sit in a prison counselor's office and describe taking $237,000 from a dying man as something they earned, and mean it. That is not evil as a simple concept. That is something harder and more troubling and more human than that. Thomas Reimer spent 7 years with someone who cared for him and controlled him and loved him, perhaps in the specific and distorted way that a person loves something they have decided belongs to them. He died in March 2011 in the farmhouse he had bought with the woman he had loved for 39 years, cared for by the woman he had chosen at 71. Whether he died exactly as his physician recorded, whether that is the complete account of what happened to him in those final months, is a question the jury considered for 6 days and answered with a not guilty that the standard of proof required, and that Rachel Mbeki and Paul Strang and Thomas's 3 children will carry with them regardless. What is documented is this: he was isolated. He was financially stripped. He tried, 3 months before he died, to reach his solicitor without Greta knowing. He did not manage it. The farmland that Thomas Reimer bought in 1979, that he wrote a specific provision around in his 1998 will so his children could keep it. That land is being farmed by a commercial agricultural operation in Waterloo, Ontario. Nobody in the Reimer family owns it. Nobody in the Reimer family can buy it back. The law gave them what it could. It could not give them that. These stories, the ones that end in courtrooms, in sealed settlements, in sentences that the families say are both justice and not enough. They are never really about money. They are about who was seen and who was invisible, who was chosen and who was passed over. What happens when the people who should be closest step back, and what rushes in to fill that space? Every person in this story was trying to secure something: Thomas's children, the life they expected to inherit; Greta, the stability she had never been given; Thomas himself, perhaps just the warmth of someone who stayed. The court decided what law could decide. It could not decide what any of them actually deserved. It rarely can. What I know, what every document in this case confirms, is that Thomas Reimer's final years were smaller and more controlled and more frightened than they needed to be, and that some of the people who might have prevented that were too far away to see it until it was already over. That is not a verdict. That is not a sentence. That is just true. And sometimes the truest things are the ones nobody gets punished for. If this story stayed with you, if it raised questions you are still turning over, then you are exactly who this channel exists for. We cover the cases where family and money and law intersect in ways that do not resolve cleanly. The stories where the verdict is real, but the wound is longer than the sentence. Where the farmland is already sold, and the recorded voice is the only thing left of the man who was trying to speak. If you have not subscribed, the button is there. If you know someone who needs to hear this story, someone who is watching an elderly parent's world contract, someone who noticed something and does not know what to do with it, send them this. This is why we're here.